Breaking news out of Georgia in the case of Knox versus the state of Georgia. The Georgia Supreme Court has rejected a challenge by professors who did not want guns to be allowed on campus at the University of Georgia. This is a big win for the gun rights movement. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. It's on Kindle and audiobook if you like to get your information that way. All right, folks, good news, good news. In the case of Knox versus state of Georgia, the Georgia Supreme Court has rejected a challenge by 5 professors at Georgia who argued that the state legislators' authorization of guns on campus, with some exceptions, was unconstitutional. That was the argument by these professors who sued to challenge the new carry laws allowing carriage at the University of Georgia and throughout that system. I'm happy to report in a unanimous decision, the Georgia Supreme Court has rejected this challenge to the liberalization of those gun laws in Georgia. Specifically, and this is important, the arguments made by the plaintiffs in Knox versus Georgia was that the legislature of Georgia did not have the authority, I kid you not, that the legislature of Georgia did not have the authority to liberalize gun laws to allow people to carry on the state property consisting of the University of Georgia and the whole campus and the whole system, in fact. Their argument mirrors an argument that I talked about and warned you about last year in the summer of 2022. You may recall, for those of you who've been with us from the beginning on the 4-Boxes Diner, Second Amendment channel, that in Montana, this kind of legal argument was successful. Specifically, and this is absurd in my view, just absurd, but specifically in the case of Montana last summer, the Montana Supreme Court said indeed that a state law passed by the Montana state legislature allowing guns on campus at the University of Montana was unconstitutional. Did you hear what I just said? It was unconstitutional because under the Montana state laws, they had set up an independent board of trustees that oversaw the University of Montana. And as a result, the legislatures lacked the authority to tell this board of trustees over the University of Montana what to do and what not to do when it came to university and educational institutions, including setting policy about whether or not guns are allowed on campus. Now, this is absurd and silly, and probably if I laser focused on the Montana Supreme Court, I probably could identify how we got to this outcome. But I'm not going to, because that's really up to the people in Montana. But I'm sure the Montana Supreme Court is full of exactly what I would expect, probably handpicked by various liberal organizations, including bar organizations and maybe the plaintiffs' bars. I don't know that for a fact. I'm just guessing, and my guesses on this stuff are actually not that bad. But nevertheless, the Montana Supreme Court would not allow guns on campus, even though the state legislature said they could be allowed on campus because of this technical argument saying that the Board of Trustees of Montana could stop it. Well, this exact same line of argumentation, this is why I teach you this stuff, folks. This is why we have to get into this nerdy, geeky stuff. Because what happens in Montana in 2022 finds a way to come back in other parts of the country. And I use this channel to teach you what happens on Montana will eventually come to your doorstep. And that's why I flag these things ahead of time, because I'm actually pretty good at predicting how things work out. That's what made me a pretty good lawyer for a long time. So with that said, the Montana argument that succeeded for the gun control movement, they brought that effectively in Georgia, and I'm happy to report it failed. It failed in the Georgia Supreme Court. Specifically, the Georgia Supreme Court said in this instance, though, that it was a moot point because not only did did this legislature of Georgia allow for carry of guns on campus with, again, some exceptions. I'll put a link to this opinion down below. You can read it and check out the footnote number 19, I think, lays out the exceptions. But specifically, not only that, the Board of Trustees that oversees the University of Georgia system basically went along with what the legislature said, so everyone was on board and rowing in the same direction, saying, yeah, you can bring guns on campus with certain exceptions because that's what the legislature wants and that's what the Second Amendment says, so it all made sense. But nevertheless, there was this lawsuit brought by these professors that literally argued that guns on campus make life more dangerous for everyone, and they tried to get it knocked out using basically the same sort of theory as I see it that was used successfully by the gun control movement in Montana. They tried to do it in Georgia, but I'm happy to report it has failed in this, I think it was a 17 or 18-page decision by the state of Georgia Supreme Court, so that's good news. So just to be clear about what the professors were arguing in this case, specifically if you look at page 11 of the opinion by the Supreme Court, it says that the professors in their complaint articulated in detail reasons that they believe why the revised policy regarding the carrying of weapons on the University of Georgia campuses following the various amendments by the state legislature, greatly increases the risk of injury and death to themselves, their students, and other persons on the University of Georgia's campuses, and significantly impairs their ability to fulfill their role in the educational mission of the University of Georgia. So that was the argument that was being advanced as a matter of principle by these plaintiffs against the state of Georgia and trying to, get guns kicked off the University of Georgia campus. Specifically, their legal argument went this way. They said that basically the legislative assembly or the legislatures of Georgia, quote, usurped the Board of Regents' constitutionally conferred exclusive authority over the government control and management of the University of Georgia, specifically the board's authority to regulate in its independent judgment guns on college campuses. The professors allege that they were injured by what they deemed to be a separation of powers violation. That's on, again, page 11 of this opinion. You can check it out for yourself. Again, the bottom line is the Supreme Court of Georgia said, nope, this is all moot because everyone agrees that guns on campuses make sense and they should be followed. So there's no other side to the argument. A nice try, but we're going to kick you out in court and dismiss your case on the grounds that this is all a moot point. Nevertheless, again, we saw what the gun controllers did in Montana with this kind of line of attack. We saw what they've just done in Georgia. So for those of you out there in various, even the red states, you got to pay particular attention to this. Make sure that the anti-gunners in your state are not trying to deny guns on campuses because, again, we know the gun-free zone signs do not work because if they worked, as I point out in my book, Disarmed, what the Ukraine War teaches Americans about the right to bear arms, that obviously if that's all it took to prevent the Russians from invading Ukraine and to protect the Ukrainian people from the invaders, we could just put up a bunch of no guns allowed signs or perhaps no missiles allowed signs on the Ukrainian-Russian border, and that would have solved the problem. That obviously did not work, as I point out in detail in my book, and that's why the anti-gunners, including Joe Biden, are sending arms to the Ukrainians to defend themselves against the invaders because arms are what thwarts people from doing bad things to good people, and so on and so on. So, okay, folks, I hope you learned a little bit something today. Check out the opinion down below of Knox versus State of Georgia, and pay attention to this movement, this sort of attack by different people that don't like guns as to how they're trying to keep guns off campuses, which, of course, in my view, makes campuses more dangerous because the students, they're entitled to life and liberty, and they should be entitled to exercise their Second Amendment rights, no different than they're entitled to use their First Amendment rights, and they're how the rest of the Constitution applies to protect their rights, just like it does for a 50 or 60 or 70-year-old as well. They're adults. They should be treated as such as a general matter as I see it. So, okay, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.